let's talk about direct examination. We're going to talk about the top 3 things you need to keep in mind when constructing a direct examination: case analysis, organization, and delivery. Let's start off with case analysis. So before you even jump into drafting your direct examination, you have to understand where you're going, right? You need to have a roadmap. Where do you look to figure out what your roadmap is? Well, the first thing you need to look at is the complaint that has been filed in the case, right? You want to know what are the causes of action. If you are a criminal practitioner, you want to know what statute, what has to be proven. In civil cases, what does the plaintiff have to prove? What are the damages that have to be proved? As a defendant, what are my affirmative defenses? Or what are the holes that I can poke in the plaintiff's case? So where do you go to figure that out? You look at the complaint, you look at the answer. If you are in a state that has published pattern jury instructions, that is an amazing resource. So that is going to be your guide for figuring out what do you need to prove, and when you're looking at that witness, how does that witness that you are attempting to direct going to prove your case? So that's case analysis. Once you have figured out what facts you need to prove and how this witness helps you prove those facts, the next thing you got to figure out is, how in the world do I organize all of these facts, right? This is oftentimes the most difficult part of constructing a direct examination that my students have, is organization. And I think it is because, as one of my mentors says, the one thing that you have to do to become a lawyer is the worst thing for you to become a lawyer, and that is go to law school. Because we are so focused on objectivity and focusing on analysis that sometimes we forget to just be regular people. So when you are organizing your direct examination, think of it as a conversation, right? What's a normal conversation like? You don't just walk up to someone and say, tell me about the things that happened on May 12th of 2006, right? You say, tell me your name. Where are you from? Are you married? Do you have any children? Where'd you go to school? That's exactly how you want to organize your direct examination, as a conversation. And I think if you keep that in mind during the course of your organization, what do I want to know next? What would I naturally, in a natural conversation, want to learn next? It will help in terms of your organization. The other thing that helps with organization is incorporating what we call transitional phrases. What I have learned with jurors is oftentimes, many of them in opening statement have decided, okay, I just need to know X in order to make a decision. And so I'm really not going to pay attention until Sara is talking about X. They may have decided, look, this was a rear-end collision, and so we know who's negligent. All I need to hear about is damages. And so you want to incorporate transitional phrases so that for that particular juror, when they hear that phrase, they know to key in. So what is a transitional phrase? That is something like, now that we've finished talking about the wreck, let's talk about how you were injured in this wreck. What happened next can be a transitional phrase. Oftentimes I found that it's easier to loop the end of an answer into your next question for your transition. The last thing we want to talk about is delivery, which can be the most important factor in any direct examination. So the first thing is, where do you stand? If you are in a jurisdiction that allows for movement in the well, which I practice in a jurisdiction that does, I always call it the 13th juror position. Why do we call it the 13th juror position? Because you are here at the corner of the jury box. The witness is going to be in front of you, somewhat at an angle, so that you are positioned where if you're asking them questions, they are looking at you, but it seems like they are making eye contact with the jury, because that's what you want your witness doing. You want them talking to the jury. But you are also positioned here because we hope you are going to be asking what I call 13th juror questions. So, tell us your name. Tell us what happened. Explain to us. What that does is it makes you one of the jury. It doesn't make you separate from them. Oftentimes my students will say, well, the first trial I observed, they said, state your name for the record and spell it. Well, that's not how you start a conversation, and that's not going to get you anywhere in terms of the 13th juror position. So when you are delivering, you want to stand such that you are just a voice in their head. You are the voice that is asking the questions that they want to ask. And so they just think of you as one of them, not as some lawyer, because people don't really like lawyers, right? But they like regular people who sound just like one of them. The other thing is you want to deliver the questions in such a way that they are conveying the emotion of the question at that time. So if you are asking about something sad, but you don't sound empathetic or sad, it's going to be weird, and it's going to sound off, and it's going to sound contrived and fake. And so you want to be in the emotion of your case. If it is something that you want the jury to feel angry about, then your delivery should be more angry. But the questions that you're asking should have emotion and should incorporate the jury. So to sum up direct examination, and my 3 best tips is: 1, you have got to analyze your case. 2, you want to organize your facts in a manner that is conversational. Remember how to have a normal conversation. Don't let law school teach it out of you. The last thing is to remember the 13th juror principle when delivering. Incorporate yourself. Make the jury feel like you are just one of them, and you just have the opportunity to actually ask the questions that they want to ask.